I call Raymond Huo.
Thank you, Madam Speaker. This must be the 13th bill that the Justice Committee has sent the bill back to the House for the second reading. And the extraordinarily busy Justice Committee has considered 20 bills this year. And on that note, as well as estimates, any reviews, inquiries, and petitions. So on that note, and in my capacity as the chair of the Justice Committee, I would like to thank all the members of the Justice Committee, thank the clerk and his team, thank officials and advisors, and especially the submitters who have taken the time to get involved and played a very important part of this legislative process. As well as the SOP 185, Minister Little has just introduced. This crime amendment bill seeks to appeal 3 sections in the Crimes Act 1961 relating to immunity for spouses as an accessory after the fact. The offense of blasphemous libel and the year and the day rule. This is relatively small, straightforward, but very important bill. We have received 42 submissions from interested groups and individuals. Most submitters commented only on the repeal of the blasphemous libel offense. A small number of submitters also raised issues about the repeal of the year and the day rule, as well as issues concerning the basic principles of retrospectivity. Immunity for spouses as an accessory to a crime after the fact is out of step with the modern society. There's no justification for such a protection. Being married or in a de facto relationship or civil union relationships provides no reason to protect those who intentionally obstruct justice. Now, what is worth noting is that this kind of immunity does not apply in New Zealand anyway. For example, under the Evidence Act 2006, all eligible witnesses are compellable to give evidence no matter their marital status. Blasphemous libel provision, namely Section 123 in the Crimes Act, is little known. No prosecutions for blasphemy have occurred since 1922. We have heard submitters who expressed the view that we may need to protection against religious conduct, but the majority submitters believe that the current provision is an unwarranted restriction on the right to freedom of expression, and that it does not align with the values of modern New Zealand. Now, the year and a day rule has attracted much attention. The rule in Section 162 of the Crimes Act 1962 is death must be within a year and a day. Repeal of this section would allow the prosecution of an alleged offendant for his or her act or omission that resulted in death more than a year after that cause of death. The repeal could mean, in future cases similar to the CTV building collapse, that there would be no bar to prosecution after a period of, say, 25 years. The government announced in March that we would remove the year and a day rule from the Crimes Act. The Prime Minister, the Right Honourable Jacinda Ardern, was quoted as saying in the staff reports that she had made an undertaking to the families of the 115 people who died in the CTV building collapse in the 2011 quake, that changes needed to be made, and we have honoured our promise. There are other cases that illustrated the problems with the rule. The issue came to light in New Zealand following a 2017 death of a victim 15 months after he was assaulted. In the United States, during the attempted assassination of President Reagan in 1981, the White House Press Secretary James Brady became permanently disabled from a gunshot wound. He died some 33 years later, and his death was ruled a homicide caused by the gunshot wound. However, the attempted assassin could not be prosecuted, and the year and the day rule was cited as one of the reasons. Other comparable jurisdictions, notably the United Kingdom, the United States, Ireland, and Hong Kong, have respectively abolished the rule, and in other countries such as Germany, Scotland, and France, the rule has never applied. One thing that we will need to be mindful is that in the United Kingdom, there was no statutory basis for such kind of a rule, as it is a purely judge-made common law. But in New Zealand, we have codified the rule. So there are strong cases that we must make such kind of changes through a legislative process. There are some issues regarding the timing of the year, as Dr. Smith just outlined, more specifically around the issues concerning the basic principles of retrospectivity. The short answer is no. Minister Andrew Little outlined his reasoning behind the conclusion, because it is fundamentally a principle that is widely accepted. It is also in breach of New Zealand Bill of Rights Act 1990, because Section 26 sub 1 of the New Zealand Bill of Rights Act spelled out very clearly as to the reason why retrospectivity shall not apply. Now, we have heard from some of the national members, and Dr. Smith in particular, who have said that they would have a view that sort of a year and a day rule and the appeal of which is kind of a loophole. With due respect, they were in government, and there were plenty of different ways of closing such kind of loophole if they genuinely believe it is such a case. They were in government for 9 years, and they didn't do it. And we are in government for just more than 12 months, and we have done that. Thank you, Madam Speaker.
I call the Honourable Maggie Baring.
Thank you, Madam Speaker.